Yesterday, we heard in compelling terms about the very significant challenge we face in realizing justice for all. 5 billion people around the world have unmet justice needs. We at WJP are proud of our work to measure rule of law issues through surveys and other data points. And we have been pleased to contribute that expertise to efforts in diagnosing the justice problem. We also put great emphasis on finding, documenting, supporting, and promoting effective solutions. It is those solutions to which we turn today under our theme of showcasing what works. There are 5 highlights to look forward to today. First, we'll start with a plenary panel of remarkable justice leaders pursuing meaningful change to bridge the justice gap. Second, we will have our World Justice Challenge presentations. Following the plenary, coffee will be served in the breakout rooms, as we are eager to get you there to hear from the 30 finalists of our challenge. The World Justice Challenge is our competition to identify the most promising, replicable, and scalable solutions across a wide range of justice issues and contexts. We encourage you to take in their presentations, to visit their booths in the expo during coffee breaks, over lunch, and at the reception. Then, using the meeting app that I'm sure we have all downloaded already, let's vote for our top 5. A panel of judges will evaluate the projects and your votes to select 5 winners who will be announced at our closing plenary on Thursday. Third highlight of the day, we have a rich array of working sessions in which we aim to learn from one another, to share innovations and best practices, and together solve problems that get in the way of justice. We owe a big thank you to the many justice organizations, thinkers, and actors who are leading these sessions. Fourth highlight, late in the afternoon, we will gather again for a plenary session and the very special presentation of WJP's highest honor, the 2019 Rule of Law Award. Last, certainly not least, our 5th highlight will be a theatrical presentation entitled Africa on Trial, and a reception hosted by the Jones Day Law Firm. So we have a full day ahead of us. And as Bill Newcomb reminded us yesterday, we have work to do. Let's get started. Let me turn over the floor to the Executive Director of the Open Society Justice Initiative, an invaluable co-producing partner of the World Justice Forum. Ladies and gentlemen, Jim Goldston.
Thank you very much, John. Good morning, everyone. Great to see you here. We have an exciting panel for you. The report of the Pathfinders Justice Task Force is a landmark event. It presents a devastating indictment of how many people continue to be left behind and excluded because of a lack of justice. And it gives us new data on the impacts this has on individuals, communities, and entire societies. It also offers us a way forward by showing us examples of what is working. And we're going to turn to that now. This morning's session is designed to offer examples of what some term success in different ways, where and how the justice gap has been and is being addressed. And I think the examples in the report and that you may hear from here this morning all highlight certain themes. I just want to flag 3 of those. One of them is that governments have to make justice a priority. The justice gap will not be bridged simply through the normal development process. It requires dedicated political recognition and resourcing. Secondly, civil society involvement, I think we will hear, is essential. Grassroots justice groups can often be faster and more effective in delivering durable solutions. And finally, partnerships are key. The greatest success stories often arise from collaboration between civil society, government, the private sector, with each reinforcing the other. So we have a wonderful panel to delve into this area. Starting on my far left, Sabrina Mahtani is the policy advisor on access to justice for the elders and the co-founder of AdvocAid. Anabela Pedroso is the State Secretary for Justice from Portugal. Sergiy Petukhov is the Deputy Minister of Justice of Ukraine. And Jim Sandman is the President of the Legal Services Corporation of the United States. And as you see, we have made the gender lines very, very clear today. So I'd like to start, if I can, by asking each of our panelists to offer a few words in describing a specific initiative that they have undertaken to address issues concerning access to justice and help us understand what are the critical ingredients that are making success possible in that endeavor. And Sabrina, if I could start with you, please.
Thank you. Good morning, everyone. So in 2005, I was working in Sierra Leone just a few years after the end of an 11-year civil war, and we met many women who were in prison for years without going to court, often with their young children. At the time, Sierra Leone had only 400 lawyers for a population of 6 million people, and the majority of these lawyers were based in the capital, Freetown. In fact, in some towns, there was only one lawyer. So in order to meet this justice gap, we started AdvocAid. We trained paralegals, women from their communities, to offer legal advice and assistance, and also hired some lawyers on a part-time basis to help with the more serious cases. 13 years later, AdvocAid now works in 8 towns across Sierra Leone. We've provided legal advice to thousands of girls and women and freed 5 women on death row through appeals. Now, I must stress that the heroes of this work are the paralegals and lawyers in Sierra Leone. I'm merely an ambassador for them. And I want to share the story of one of the paralegals, Marvel. She's a young woman from Freetown. In 2011, she was detained for 7 days in a police cell due to a minor dispute. And due to AdvocAid's intervention, she was released. But this experience of injustice made her so passionate about justice, she came to volunteer with us and later trained as a paralegal. And Marvel has helped to reduce the time that women spend in pretrial detention in Sierra Leone by mediating minor cases, stopping the police charging bribes to women, helping find sureties, providing legal empowerment training to groups of women. So much, she's been so effective in her work that the police even gave her a nickname, Small Pepe, which means small pepper. And if any of you have been to West Africa, you know that these peppers are very hot and quite forceful. And just briefly, as Jim mentioned, to outline, I think, 5 ingredients to what has helped make some of AdvocAid's work successful. One is that we use a low-cost model. So paralegals are much cheaper and quicker to train. I think it took me at least 6 years to train as a lawyer. Secondly, our work is holistic. We don't just focus on access to justice needs, but we try to respond to other needs a woman might have. For example, trying to provide gender-sensitive health products when a woman is in detention. Thirdly, innovation. We try to embrace innovation as much as possible in our work. For example, we've used creative strategies in legal literacy programs, and we started the first ever legal education TV and radio series called Police Case in Sierra Leone. And fourthly, as Jim outlined, partnerships. This has been so key to our work, and we're very fortunate to have good partnerships with government and civil society groups. And I just want to take a moment to acknowledge Minister Schwartz and all the positive work she's been doing in Sierra Leone, as well as many of the Sierra Leonean civil society groups who are here today. And actually also OSJI, thank you, Jim, because we're very fortunate to benefit from OSJI support with our paralegal training. And lastly, AdvocAid uses our service delivery work to press for longer-term policy change as well. As an example, we were part of a coalition of organizations that pressed to have a legal aid bill in Sierra Leone. This was passed in 2012, and I think is one of the most progressive acts on the continent. It recognizes the role of paralegals, and the act also recognizes the important role that civil society has to play in access to justice.
Fantastic. Thank you much, Sabrina. And we will come back to that, I hope, because that's a fantastic example of an effort to bridge the gap on access to justice. Anabela, if I can turn to you, you've been a pioneer in Portugal in this work. Can you tell us a little bit about what you see working there?
Of course. Good morning to everyone. And another dimension that Sabrina talked about is life in court. And we began with the problem. And the problem was the perception and the truth that the citizen had, the complaint about lack of simple and transparent information in courts. And on the other hand, internally, we had a problem that was a very slow resolution time of processes. As a matter of fact, in 2016, we began our project having almost 1,200,000 processes pending in courts. So that was a problem. And what we asked ourselves was, how could we turn this long-term problem in a short-term implementation? And how could we start doing something different, and beginning by a question, how can we do it differently? And that's why we began a project that we called Court Plus. In our opinion, if we don't have names, we don't have identity, and it was important to give a name to the project. And Court Plus came with 3 dimensions. The first one was the possibility to have a different experience for citizens when they went to court. Is that possible to centralize service in the front office as if we were in another area and not in a court? The second part was, is it possible to re-engineer the processes in the back office, not implementing something that goes directly with the independence of the judges in the decision? No, I'm speaking about administrative processes. Could we do it differently? And the third part was, why can't we do it online if there is the possibility to dematerialize services? So with those 3 questions, we began what we called a lab. As a matter of fact, our methodology is always the same. First prototype, second pilot, and then spread out. And when we began the prototyping, we do something that I suppose it was daring, I think. We began in the back office, and we began using something that it's not very used in public administration, I can say, and less in courts. We use what we call the lean methodology. What does it mean? Well, do you remember in the 70s and the 80s when Toyota began something that was to create a manufacturing system that was very efficient in the back office? So exactly what we did in courts. We invited a Japanese company and institute, a family, Kaizen, to come to Portugal and to help us to see how it will be possible to take off the, I'm sorry to use the term, the fatness that we have, the fat part that we had in processes inside courts. And something that was very important, and we learned with them, that the most important word to do this new way of working inside courts was collaboration. And in fact, even the design, the prototyping of the design of the front desk was made by bailiffs, by the clerks in the courts. So when the project began, the second part of, and the challenge of this system was to create a connection between the Superior Council for judges, the General Attorney, for the bailiffs, and even for the Ministry of Justice. And after some time, we began a pilot in Sintra, as Sabrina had the opportunity to see. And it's very difficult sometimes to express in words. So I invite you all, if you come to Portugal, besides a beautiful country and lovely areas that you can see, come and see our courts. Because today we have almost in 150 courts the system working. And what is the system? Well, me as a citizen, I go to a court and I have a front desk that is completely centralized. And there I can ask for an information, I can see my process, and even I can have a certificate. And then if I go for an audience, what I do is I have a check-in, like I have in an airport or in another area. And in this check-in, I will have an idea of what will be the room that I will be there. And at the same time, the judge knows in the back office that that person is there. So in the end, he can have the decision, well, let's begin the trial, or He can say, well, I don't have the testimonies that I want, and so I automatically send a SMS to the lawyers and tell them, sorry, it's not the moment, so you have a postpone and you can return in such day and such hour. And so after what I have to do in court, when I do my checkout, I will receive a declaration that tells, if I need it for my job or something, that tells everyone that, well, you have been here, and the time that you have been here is that one. The experience for the user and the experience that we have for the citizen is completely different, because now it's a citizen-centered service. But for me, the most important and the only part that was amazing is the back office. To see how differently they are working. You know, sometimes it's not a question of technology. Of course we are using technology, but the most important was to see clerks using something that it was so interesting as looking to a paper and say, why am I having this paper here if I can have it there? If we can share with us, and every morning in 5 minutes, they ask themselves, to all of them, what are the processes that you have? What will be the goals for today? What can I do better and I can help you? And this changed completely the way how they work inside. And even when you go to the back office, you see a clean environment, you know? It's very difficult to work and to be efficient if you work in a mess of paper, in a mess of dust, and in a mess of yourself. And so organizing, put everything together and work in a very collaborative way, change everything. And even for me, that I'm working for many years in those areas of re-engineering, I was amazed how it was possible in 2 years to have such a difference in our courts. As I said, we began with 1,200,000 processes pending. We increased the productivity from the back office in 30%. And yesterday, we had the statistics, the official statistics for processes, and we have a reduction of 400,000 processes. In 2 years, we did the difference. And it's not a question of government doing it. It's a question of working together, citizens, ourselves that are in public, in government, and especially the ones to whom we address what we are doing. And so I think that the factor that was incredibly important was that. And secondly, was the way how we work. We don't have too much money. We need to be very assertive in what we are doing. And the methodology of prototyping, involving, and then piloting, and then spreading out the system gave us the opportunity to make it better, to amend errors, and in the end, we feel that exactly we are doing the change in courts in Portugal. Thank you.
Thank you so much, Anabela. A fascinating example. The use of efficiency in the automotive industry as a model for the judicial system. I wonder what will happen as we move to self-driving cars. Do we get to self-driving courts? We'll have to see where that leads. But that's really fascinating. Thank you. So we've heard about broadening access to justice in Sierra Leone. We've heard about increasing the efficiency of justice and the transparency of justice and improving the citizens' experience with justice in Portugal. Sergiy, I wonder if you could tell us, Ukraine has been going through some political change over the years, but nonetheless, or perhaps because, you've been having quite significant success in the justice area. Can you tell us about that, please?
Right, good morning. So, of course, Ukraine has been in the front lines of the newspapers for many things, but I think what matters to us is that the revolution of dignity that we had, how we call it, was about justice and access to justice. And there is still a popular quest on the people's side to have more justice in the country. So we've established a relatively new free legal aid system covering the whole country. It's now 4 years old. But when doing that, we've realized that we have a problem because 55% of our people have never tried to defend their rights. They don't know what they can, what are the ways to do that, and so they decide not to do anything. So in order to counter that, we've decided to do a national awareness project, I Have a Right, through our free legal aid system and the whole justice system, to make sure that people know what rights they have and the ways how they can fulfill them. We've identified sort of the top list of the problems that people are facing through sociological reports and questioning. And what usually happens when you have sort of a problem that concerns many people is that it's not a problem of, an individual problem, it's a structural problem, either through the deficient legislation or something is not working in the system, in the legal system, or there are some misconceptions within the society. And so when designing the project, so we were going on the specific thematic areas, but we were looking sort of holistically in terms of whether we need to change the legislation, why people are not reporting a certain problem, why they don't trust the court or policemen, or why they're not talking about it. Is it too complicated for them? Is it too costly? What's the problems are? In doing that, we worked with the civil society organizations. They're much more closer to people, concentrating on specific problems. They know what's going on. They know how people feel about the specific problem and why they're not really taking legal ways of resolving it. I will give an example. Something that would probably not fly internationally, but was a big problem in Ukraine, is the recovery of child maintenance money. So when people divorce and somebody has the care of the children, the other parent is supposed to pay the money. And that is a big social problem in the country. We have many people divorced, which is fine, but then the other parent is not paying the money that is due for the child or the children. And we've actually have court decision obliging the person to pay the money, but this would not be enforced. And the overall number is 600,000 cases of child support. Many of those would not be successful. Why? Well, firstly, we have lots of people who do not work officially. They don't have any official money they're making, so you can't enforce it against the official salary. We have people who dodge their property, writing it off to other people, their relatives, etc. So you end up with many Muslim mothers without any redress. They have the court decision obliging a man to pay, but that would not happen. So what we did, we've changed the legislation. Now, except for this normal way or normal procedure in the court, a person who does not pay the child maintenance could be barred from going abroad. His driver's license could be taken away, and his hunting license and certain other licenses be taken away. And this could have been done without a court decision, just by the decision of the enforcement agents. So we've had about 100,000 decisions like that, and we've seen many, mostly fathers again, going back and paying voluntarily the money that they've never would have paid otherwise, because that actually hurt. When you can't drive your car, for many people, that's a big problem, right? We've also did what? Some people said we don't have jobs, so we partnered with other state agencies looking for jobs to them, usually community jobs working for the local councils, and in this way, they would have the official job, but also would pay the maintenance to their children. There was another problem, when we've done that, what helped us a lot, we got a sort of mainstream attention because we had some, TV celebrities getting divorced and having this row over their children. So they were going to the Ministry of Justice as well and sort of using our legislation and our advice, and that was all, televised. In this way, I think we've raised the topic to the mainstream agenda and awareness of all the people. But then we had fathers coming to us, fathers organizations, say, well, it's imbalanced because while you're now working to protect mothers, you're not doing anything for fathers. And there's a problem with the access to children. So like when mothers don't give fathers right to access. So that was another problem that surfaced. And we're working on that. That is a bit more complicated. It's harder to ensure that, this schedule of visiting the child is there. But as a result, we've reduced the number of outstanding child maintenance cases by 100,000. So out of 600,000 pending cases, we now have 100,000 less. So that means much more children have the money that they need to be raised and ensure a healthy and sustainable living. We've managed to raise this problem to the awareness of all of the society and have lots of people express their judgment on what needs to be done about it. And we've introduced the changes to the legislation that made it effective to our system to fight those cases of people dodging their obligations. This is just one example, but there are many others that we worked on, things like consumer rights, domestic violence, other cases that are either underreported or hard to navigate within the legal system. I will stop here.
Thank you, Sergiy, very much. So that's a great example of not only creating the institutional framework to provide legal services, but actually ensuring that it's actually used meaningfully by people who need it. I think that's fantastic. Jim, let me turn to you, if I may. We hear a lot about what is not working well in the United States these days. You have a very long and distinguished career in helping things in the justice sector work better. Can you tell us about one such initiative that you've been working on?
Yes. Thank you for having me here. It's great to be here this morning. I'd cite one project, the Justice for All project of the National Center for State Courts in the United States. The goal of the project is to provide effective assistance to 100% of people who have essential civil legal needs. The name of the project happily mirrors the theme of this forum, Justice for All. This is not a project of the Legal Services Corporation, which I head, although it has its origins in a Legal Services Corporation technology summit that we convened 6 years ago. The goal of our technology summit was, in the words of the statement of purpose, to explore the potential of technology to move the United States toward providing some form of effective assistance to 100% of persons otherwise unable to afford an attorney in dealing with an essential civil legal need. The words were chosen carefully. Some form of effective assistance, not necessarily a lawyer for everybody, and for 100% of persons. For many years in the United States, up until today, we have had a system that leaves more than half of people with essential civil legal needs with no help of any kind. The Justice for All project was adopted by the Conference of Chief Justices and the Conference of State Court Administrators, the bodies that oversee the state court systems in our 50 states and territories. In 2015, they took that concept of the LSC Technology Summit, but they broadened it. They broadened it in two ways. First, they didn't limit the concept of assistance to technology. And second, they didn't income limit it. It wasn't just limited to low-income people. So they set an aspirational goal of providing effective assistance to 100% of persons with essential civil legal needs using what they called a continuum of meaningful and appropriate services. There are now 7 states that are pursuing strategic plans with measurable goals to try to implement this concept. The concept has 3 components. The first is it is user-centered. Too much of legal assistance in the United States was designed by lawyers. To people who are not lawyers, the system is opaque and confusing and complicated. Second, the system contemplates broad collaboration across a range of stakeholders and participants, not just judges and court administrators and bar associations and law schools and legal services providers, but also community organizations, social services providers, human services providers, information services providers like public libraries, the public, to engage them in what this comprehensive model of assistance might look like. And third, the model contemplates, as the Conference of Chief Justices put it, a continuum of appropriate and meaningful services. That would include information available through technology online tools, self-help tools, self-help resource centers, perhaps located in courthouses, navigators to assist people through court processes in contested matters. It would include assistance with negotiation and mediation, and in appropriate circumstances, it would include a lawyer. For those who can't afford a lawyer, either a legal aid lawyer or a pro bono lawyer. For those who can, a lawyer who may be providing what they call unbundled legal services or limited scope representation. What is appropriate would depend on the circumstances. Ideally, when this concept is implemented, it would have a triage feature, which would tailor the assistance made available to the circumstances of the user, taking account of things like the nature of the matter, the capacity of the user, in a contested matter whether the opponent is represented, and what's at stake, how important is it? So those three components, user-centeredness, collaboration, and a spectrum of services are all geared toward this goal of leaving no one with zero help and everyone with some form of effective assistance. Let me give you an illustration of how this reflects a rethinking of the service delivery model in the United States. Alaska is one of the states that's been pursuing the Justice for All project and has a strategic plan to do it. Alaska faces many challenges in service deliveries. It's the largest of the United States, twice as large as Texas, 1/5 the size of the lower 48. It has a small population. In 2018, the population of Alaska was 737,438 people. So they have a small population dispersed across a very wide geography. They decided that if they were going to be able to implement this project, the concept of justice for all, they really needed to look differently at the population they're trying to serve. So they mapped delivery of services by different components of service delivery in Alaska, focusing in particular on the location of courts, the location of legal services providers, the location of social services providers, the location of healthcare providers, and the location of information service providers such as libraries. And what they found when they mapped up the locations of other service providers was that by far the biggest reach, the best network, the best depth of reach in Alaska was through healthcare providers. So they determined that if they were going to succeed in this goal of being truly collaborative, they needed to engage healthcare providers in the delivery of legal assistance by educating healthcare providers about how to identify a legal problem and by educating them about the resources that are available for referral for those people who do have legal problems. What a creative concept. But that's the kind of thinking I believe that we need to have if we're going to implement this goal of justice for all.
Thank you, Jim, very much. So again, we're hearing, I think, a reiteration and a different manifestation of a theme that if we're going to address the question of access to justice meaningfully, we need to be thinking about more than lawyers and judges, important though they are. Sabrina, can I ask you, I'm hesitant, but I think we need to touch on the subject of money. How do we deal with the question of sustaining financing for justice services in the holistic way that you and others have described, in political climates that are often not very receptive, where governments are resource stretched? What works? What do we do?
Thank you. I think that's the greatest obstacle that's facing many grassroots justice defenders. I think Namati did a survey recently, and 60% of those surveyed said that they had a financial challenge and may have to close services in the coming year. But at the same time, most grassroots organizations operate on less than $20,000 a year, so we're not looking at huge sums of money. For AdvocAid, some of the strategies we've tried to employ is to diversify funding, to approach the private sector for collaborations. We've also tried to use crowdfunding. We've managed to raise quite a lot of money, like over $50,000 on crowdsourcing platforms. And this enables us to tap into different communities, such as the diaspora, for example, who may want to support projects back home. I think that there's lots of positive examples out there. Hina Jalani yesterday mentioned Indonesia, which not only recognizes paralegals in its law, but provides some sort of public funding there as well. Sierra Leone also has a very interesting land policy where companies who may want to lease land have to pay money into a basket fund, which can then be used to provide some resources for grassroots groups to those communities. So I think there's lots of interesting strategies out there, and I think the challenge for us now is to, use SDG 16 this year, to use the fantastic task force report to build this movement on access to justice and to really press governments to do more in terms of financing, as well as to look more collaboratively and to look at the health sector, the education sector, and how we can broaden our concept of funding for access to justice.
Fantastic. Thank you very much. Sergiy, you wanted to come in on that?
I wanted to add from the government side, because when we started our free legal aid system, it was right 1 year after the occupation of like 7% of our territory. We had an ongoing war and drop in 15% of GDP product of the country. So there was no way to find an extra money for that. So what the Minister of Justice did, we've had the small offices all around the country. And it turned out that there was really nothing that they delivered to the people. So we've closed offices around the country and opened the free legal aid offices in their stead using the money saved on that. What is happening now is that we have the programmatic budget for the free legal aid system, and we're paying money to lawyers who are representing the people. But because we're doing a successful awareness campaign, more and more people come. And every year at some point, administrator comes and says, we have no money to pay to lawyers. And he comes to the minister and says, look, we need more money. And I think the minister has always been able to talk to the government, to the prime ministers, given these specific examples on how the project works. And it actually, I think it's every government's goal to communicate the policies, to communicate what they're doing to their people, and our system is effective in doing that. And because this has been the biggest social project in the recent years, we've always managed to get the financing. So I think, the solution could be, save money where you don't need it and divert it to where, you really need it, and also show to the government how the system delivers to the people. And all the governments are, I assume, elected by the people through this or other project, and they should be responsible, and they value when they see that the people really appreciate what the government's doing. So that's how, the way to find the money.
That sounds great. So it sounds like there's, in part, a political education function as well.
Right.
Jim, do you want to share some experience?
Yeah, I'd like to elaborate on that. Government funding for legal aid is a perennial problem in the United States, although there is some good news. State governments, and in some cases local governments, are beginning to step up with considerable funding. For example, New York City has adopted a policy of trying to provide counsel to every person facing eviction in the city who can't afford a lawyer, an undertaking that they estimate will cost $200 million a year when it's fully implemented. There are comparable initiatives, but not at that scale, underway in Philadelphia, Washington, and San Francisco. So having federal funding complemented by state and local funding is a very positive development. But I think this issue of education is critically important, education of policymakers. The biggest challenge we face in getting adequate government funding for legal aid is ignorance of the problem. The justice gap is not understood outside the legal profession, and our approach to it has been too insular. The United States House of Representatives, the 435 members, have only 1/3 lawyers among them. When I go in to talk to a new member of the House of Representatives about funding for the Legal Services Corporation, and the person is not a lawyer, I may be meeting a person who is very well educated, very intelligent, and who is unaware of the fact that there is no guaranteed right to counsel in a civil case in the United States. I face that phenomenon routinely. Even within the legal profession, when I talk to big firm lawyers, I find that they do not know what's going on in the municipal courthouse down the street from their offices. So if we're going to succeed in building a movement, we need to reach out beyond the legal profession, beyond those of us who get it by attending a forum like this and by engaging many others. I once had a member of Congress tell me, I only hear from lawyers about this issue. I don't hear from people in the real estate big business. I don't hear from business leaders. I don't hear from educators. I don't hear from religious leaders about this. So they get the sense that this is a legal issue and not the societal issue that it is. One final point. I think that the challenge of funding is so significant because we've created a system that is very expensive to fix. It requires a lawyer to do too much. We need to simplify the legal system. If we did that, it would be less expensive to provide access to justice. One observer put it this way. He said, we need to make law less complex and more workable. Lawyers have been paid, and paid well, to proliferate subtleties and complexities. It is about time we brought our intellectual resources to bear on eliminating some of those intricacies. That was Attorney General Robert Kennedy speaking in 1964, 55 years ago. I think the situation has become worse since then, not better. So when we talk about funding, I think we need to get back to basics about what it is that we're trying to fix and where the real solutions are.
That's great, Jim. Thank you. I see members of the bar scrunching up in their seats, getting ready to respond. But can I just ask, in relation to this, if how many folks in this group are not lawyers? Could you just give a show of hands? Would that be possible? That's great. So that's fantastic. So we have a really good number. I know that the World Justice Project in convening this forum very much from the beginning wanted to involve many people from a variety of sectors. So it sounds like we've had another success just in this meeting by doing that. So that's fantastic. I want to turn to Anabela, and then I'm going to turn quickly to the audience. For a couple of comments. But Anabela, feel free to offer comments here on anything that's been addressed, but I'd also, if you would, given that you have unusual experience both in government and in civil society, if you could talk a little bit about concretely about the notion of partnership between civil society and government and what that means in practice.
Absolutely, James. Only one thing. Sorry if I'm going to be a little provocative. But let me share with you a little story. When we began with the online services and the possibility to see the process in court online, we had a problem with our association bar because lawyers were a little unhappy with the possibility to open what is usually for them side the partner to be the broker of what is going on in court and in the process and give that possibility to the citizen. And it was very interesting to see how something that was a phrase that we use, and I use very often, that is simple answers to complex problems, it's not very well received by them. And what I said to them, and what I would like to share is, it's not a question of being complex and using even a language that we don't understand. As a matter of fact, when we say that, well, the problem that we have with the digital transformation is because citizens don't have literacy. No, it's not a question of literacy. The problem is that the provider don't speak the language easily and go near the citizens. That is the difference. And this is something that it was very interesting to find out, that during those 4 years of working together, it was even for lawyers a work in progress to understand that giving the possibility to the citizen to know what's going on with his process in court is not a problem. By the way, it's transparency and gives even the possibility to say to the lawyer, wait a second, you said to me that you gave that paper and I don't see it there. And this is what I call user experience and especially give the power to the citizens. So speaking on the other part, that is the partnerships between private and public sector and with the third sector. As a matter of fact, I see it in two ways. For one part, our partnership with enterprises is always a tension, I can say. It's very tense because I think that big enterprises look to the public administration as a very good and a very costly provider of money and services. What happened today, and I think that with the rising of many startups that is coming, they are young people, they want to do better services and even cheaper. And one of the things that for me it was very difficult all over my career in public administration is why big companies are always don't giving everything because they want to stay there for many, many years. And so the struggle is how it is possible from the side of the public administration have good contracts if we have always this way that they don't give everything and they try to stay there, and at the same time we feel stuck and don't feel the partnership that we could have. Mm-hmm. We speak about partnership, but it's not a partnership at all. For the third sector, and as James said, I was for many years involved on that area. What I find out was that it was very difficult. Naturally, I'm speaking for my country, Portugal. It was very difficult to work in partnership with government when I was in the third sector. Why? Because exists even today some sort of mistrust between third sector and government. And sometimes I don't realize why it was. I think that is a question of ignorance. We don't know exactly what the civil society is doing. And we are creating a new sort of DNA that comes from what is the experience as citizen that I have. And that was one of the things that I'm always saying to colleagues of mine that say, I don't want to work again with public administration, or I don't want to work again with government. And I always say, please, no, continue, persevere, go there, but have a plan B. If you don't have the possibility to arrange some money, because sometimes the expectations, even the political goals are not the same as the civil society. Civil society must be and must continue to be uncomfortable for governments because it's their role. And so sometimes partnerships, again, are difficult to be made. But nevertheless, I think that it will be something that will become with a new culture of service that will put all three together, especially civil society and government.
Fantastic. Thank you very much, Anabela. That's great. So you've just said many governments don't know what civil society is doing. So let's tell them. I think we've got a couple of colleagues in the audience who wanted to share some experience, and I hope we can have the facility to make that happen. Mayang from Indonesia. We heard Indonesia mentioned. Could we hear a little bit more about what's been happening?
Okay. Thank you, James. So I would like to share about our experience in advocating legal aid laws and also the provision on paralegal. So my organization, Indonesia Legal Aid Foundation, has been developing community-based paralegal projects since the late 80s. Since then, this approach has been expanded and replicated by various community sectors, including laborers, farmer, urban poor, indigenous, and so on and so forth. And it is well aware that community-based paralegal has made a concrete contributions by filling up the gaps due to the lack number of lawyers in response to justice demands. Along with the advocacy to promote legal aid law in Indonesia, we managed to include paralegal to be recognized in the legal aid law of 2011. The Ministry of Law through BPHN has tremendously allowed civil society to collaborate with the government to draft the law. The law allows legal aid organization to recruit paralegals in delivering its legal aid services. The co-creation between the ministry and civil society was continued. Early in 2018, the ministry passed a regulation on the role of paralegal in the legal aid professions. The main consideration was based on the lack number of lawyers compared to justice demand. And the regulation was not only recognized, but also allows paralegal to be involved in the legal aid professions, including litigation and non-litigations, as well as legal aid, legal empowerment. And the regulation also required paralegal to have some standard qualification through a series of training. The regulation was also regulate the public funding to support the role of paralegal, both through the national as well as local budget. Unfortunately, in May 2018, the Supreme Court revoked the two most important provisions in the ministerial regulation on paralegal, specifically on the involvement of paralegal in providing litigation and non-litigation services. Those two provisions was challenged by some lawyers who misunderstood about the role of paralegal in legal aid professions. Currently, we are in a co-creation process between the ministry or BPHN and civil society to revise the regulation on paralegal to complete all the existing gaps and loopholes within the regulation, especially to formulate a proper definition of paralegal that clarifies the misunderstanding, at the same time accommodate various practices of community-based paralegal that have made real contribution in providing legal aid. We really hope the co-creation would go well to have the ministerial regulation that clarify the role of paralegal, at the same time ensure their independence in providing legal aid service to the community with adequate access to existing legal system as well as protection. Thank you.
Thank you, Mayan. That's great. So we just heard about the importance of recognition of paralegals. We heard about the importance of resourcing of paralegals and independent providers. We have heard in other contexts and well about the need for protection in an age in which paralegals, justice providers, rights defenders generally are under attack in so many places. Those are all needed. If I can turn to Margaret Kusambiza from South Africa. Margaret, can you tell us a little about the experience there briefly, if possible? Thank you.
Thank you very much. Okay, let me hold it. Thank you very much. My name is Margaret Kusambiza. I'm from KAWOSA. KAWOSA is the Center for the Advancement of Community Advice Offices in South Africa. And in South Africa, we've had a very interesting relationship with our government because for the past 20 years, we've been trying to negotiate to have recognition of community-based paralegals. We've had a lot of study evidence to show that really the community advice offices working with the community-based paralegals are doing a great work. Most of the communities, the rural communities, they don't have access to lawyers, and they're relying on traditional leaders and also community advice offices. And what we've been saying is that this part of access to justice is very, very essential, especially if you consider our history, where we're coming from. And we've had negotiations, and government is recognizing us. At least they're telling us that they see the value and they want to support us. But for the past 20 years, despite our efforts to have progress, we seem to be getting stuck on the issue of funding. When it gets to funding community advice offices, there seem not to be much progress. We've recently had some discussions, but again, we get, I think what has been mentioned in the past, even here today, that there isn't that, is it trust? How will this work? There are many questions, because it's never been done before. We've been working with the Department of Justice, and they are receptive, but I think they're trying to find an appropriate strategy that will work for government, but also support the community advice offices. Now, our appeal is to, I think, to develop that partnership, a genuine partnership, where we can work together. It's a new terrain that we are trying to get into. And we believe as the community advice offices, as CAWOSA, that if we trust each other and take those steps to develop a strategy, to develop a plan, a funding plan, not only to recognize advice offices, but also to support them, to make a commitment to support them. I'm sure if we own the process and work on it together, we'll definitely make progress. Because if we don't do that, for the past 3-4 years, we've seen advice offices closing down. They cannot sustain themselves. They can't get the funding to sustain themselves, and they need to be supported because what they're doing is really valuable and enables us to have access to justice. Thank you very much.
Thank you, Margaret, for highlighting not only the progress made, but some of the challenges still to be overcome. We are approaching the end of our time, but I'd like to ask if any of the panelists wish to reflect on anything we've heard in the course of this hour that you'd like to underscore or add very briefly before we close. Does anybody have anything they'd like to flag?
Perhaps if you allow me, I think that the most important thing that we are speaking about is a word, partnership. And working together is not easy. It's a question of human behavior, it's a question of character, it's a question of common goals. And sometimes when we speak about this tension between civil society and government, it's very useful and healthy that we have it. Because when we feel too much comfortable, we don't change. And that's why this sort of co-opetition that we can have, we can cooperate, but at the same time, we must have a competition, will give us the opportunity to go further in what is the most important thing, the human being and the well-being of the society. To be happy in what we are doing and to be a real citizen of the world, this is the most important thing for all of us, isn't it? That's why we are here. This is justice for all. And today I feel a little worried of what's going on in the world. In Europe, last Sunday, we have elections in Spain. And today, only 4 countries in Europe, Portugal, Ireland, Malta, and Luxembourg, don't have right-wing, extreme right-wing in their parliaments, in their national parliaments. It means that something that comes from the nationalisms are coming, and it's very, very important that we learn about the history and learn that governments will be much better if we work together with civil society. We must do that because we need to survive. Portugal is a country that 50 years ago had a dictator and came out of it. Democracy is the most wonderful thing that we have. I am the generation that came from the dictator to the democracy, and I know it so well. So in the end, the only thing that I'd like to emphasize is never again return to the past. That is the most important. That's why it's so important that we have justice for all. That's so important that we have this partnership and this possibility to work together, as our colleague from South Africa said. And thank you very much for the opportunity to be together here today.
Thank you, Anabela, very much. What a great note on which to end this discussion. I think we often, the folks in this room who are so committed to justice and deepening justice for more people, often necessarily focus on the challenges and the obstacles, and they are many. But I do think it's important that we take to heart much of what we've heard from our colleagues this morning, that there are very positive things happening in places as diverse as Sierra Leone and Indonesia and Ukraine and Portugal and Alaska and New York City. And the effort to learn from those examples in trying to bring success to other places, I think, is very, very important. So I'm very much looking forward to the rest of the discussion, given the extraordinary array of experience here over the course of the next few days. But if you can join me now in thanking our panelists for this discussion. Thank you very much.
Thank you very much, Jim, and thank you very much to an excellent panel. Just a reminder, the coffee is in the 6 breakout rooms. Please make your way to your respective rooms. The next session starts at 10:30 a.m. Thank you.